This is Democracy Now!, democracynow.org, the War and Peace Report. I'm Amy Goodman as we turn to the war in Libya and the intensifying debate in Washington over the legality of the war. On Wednesday, a bipartisan group of 10 members of Congress sued President Obama for violating the War Powers Resolution by failing to obtain congressional approval for the Libya operation after 60 days. The lawsuit was filed one day after the Republican-controlled House passed a measure that would bar funding for the U.S. role in the attack on Libya. On Wednesday, the White House responded to the criticism by issuing a 38-page report that argued the War Powers Resolution does not apply because the U.S. role in Libya is limited and thus does not require congressional approval. The report asserts, quote, U.S. operations do not involve sustained fighting or active exchanges of fire with hostile forces, nor do they involve U.S. ground troops, unquote. During a news conference on Wednesday, White House Press Secretary Jay Carney warned members of Congress not to send mixed messages about the U.S. military efforts in Libya.
We believe that the support for the overall mission, the support for the goal of protecting Libyan civilians and holding Colonel Gaddafi accountable will continue. It is support that we've had from Congress in the past, and we expect to continue because now is not the time to send mixed messages, as we've had the success that we've had in that mission.
We're joined now by two guests. Democratic Congressmember Dennis Kucinich of Ohio is with us in Washington, one of 10 members of Congress who sued President Obama Wednesday. And joining us from Charlottesville, Virginia, Robert Turner is with us. He worked as an attorney in the Reagan White House, co-founder of the University of Virginia's Center for National Security Law, longtime critic of the War Powers Resolution, author of 2 books and many articles on the subject. Well, we'll start with you, Congressmember Kucinich. Why have you sued President Obama?
Because his actions taking the United States into war against Libya were in violation of Article 1, Section 8 of the Constitution, which makes it very clear, right from the foundation of this country, that Congress shall have the power to declare war. And the President did not go to Congress for this action against Libya. We are attempting to correct an imbalance that has occurred not only during this administration, but over the years, where executives have appropriated for themselves the war power without checking with Congress. And, of course, in our lawsuit, we also address the War Powers Act, which the President is in violation of. And we also state that neither the approval of NATO nor the UN Security Council supersedes the Constitution of the United States. And finally, Amy, where's this money coming from? Who's paying for this? There's been no appropriation for Libya. We need to get some answers on that as well.
And who has sued? Can you talk about this bipartisan group, Congressmember Kucinich?
Well, yes. I mean, this is a nonpartisan issue that relates to the imperative of our Constitution to be able to withstand the buffeting that happens from both directions, left and right. This coalition, made up of members Walter Jones, who is a Republican from North Carolina, who's started off in favor of the war in Iraq and has become a very strong supporter, not only of withdrawing our troops from these areas, but also a strong supporter of the constitutional imperative to have Congress involved in its decision-making. Ron Paul's very involved in this. Dan Burton, John Conyers, who's the former chair of the Judiciary Committee and a Democrat from Michigan. We have a coalition that includes Mike Capuano, from a Democrat from Massachusetts. It's a coalition that's as broad as this country, and it's a coalition that is quite diverse politically, and I think that needs to be said because it points to the fact that there's growing opposition in this country, not simply to the war in Libya, but there's growing opposition to the United States inserting itself alone or with NATO as kind of a global cop while our priorities here at home are getting ignored. And that's something that that needs to be said right now. With 14 million Americans out of work, with 50 million Americans still without decent health care, with so many Americans losing their jobs and their retirement security, with people not being able to send their children to the schools they envisioned they'd be able to send them to, with our environment deteriorating, we are still prosecuting wars and trying to play global cop. I mean, there's other issues here, but in the court, though, we're focusing very sharply on this issue of what Article 1, Section 8 really means, and I'm hopeful that if we get standing, we'll be able to create a classic resetting of the pointer as far as rebalancing the power relationships in this country that have gone askew since executives have been appropriating the war power.
Robert Turner, your response to this lawsuit of Congressmember Kucinich and other members of Congress, Democrat and Republican, saying that President Obama is violating the War Powers Act?
President Obama's position is absolutely clear. We are not engaged in war in Libya, and thus, if the War Powers Resolution were constitutional, it still would not apply. On August 17th, 1787, James Madison introduced an amendment in the Constitutional Convention that changed the power to be given Congress from the power to make war to the power to declare war. That was a term from the Law of Nations. It was understood by all of the publicists who wrote about it, by Grotius, Vattel, men whose writings were cited by the Founding Fathers, that you only declare war when you were launching an all-out, what today we would call an aggressive war. That kind of war has been outlawed. No country has declared war since the UN Charter went into force in 1945. That clause is as much an anachronism today as the power given to Congress in the same sentence to grant letters of marque and reprisal, which were outlawed in 1856 in the Pact of Paris. I've been writing about this since the War Powers Resolution went into force. I worked in the Senate for the first 5 years. I served as acting Assistant Secretary of State for Legislative Affairs during the Reagan administration. And just in 2008, we had a national bipartisan War Powers Commission. It included Lee Hamilton, Slade Gorton, and a number of other congressional liberals, former congressional liberals. They unanimously said the War Powers Resolution is unconstitutional. George Mitchell, former majority leader, on May 19th, 1988, said in the Senate floor that the War Powers Resolution brings Congress into force short of war, expanding its power into the power of the president. It is true the War Powers Resolution tries to control this, but as Chief Justice John Marshall told us in perhaps the most famous Supreme Court case of all, Marbury versus Madison, an act of the legislature repugnant to the Constitution is void. If it's void, it's not law. If it's not law, the president has no duty to see it faithfully executed.
Congressmember Kucinich.
Well, I would like to ask Mr. Turner if he's read the filing.
Have you read the filing?
I glanced through the filing. This is political theater. The congressman certainly knows because he was involved in the Campbell lawsuit during the Kosovo operation, and he knows from history that back during Vietnam, the courts always dismiss these suits for a lack of standing. The Article 3 of the Constitution requires a case or controversy.
I beg the gentleman's pardon. I take an oath to defend the Constitution. This isn't theater. I was the second person on that complaint that Congressman Campbell filed in 1999. I see this as a serious question of whether or not the founders intended the power to declare war to reside in the legislative branch. Did they really mean it when they wrote that in Article 1, Section 8, Clause 11? Or did they mean when they went to Article 2 of the Constitution and called the President to Commander-in-Chief to mean that he could summon forth the troops without the ability, or without having to go to Congress? Our lawsuit is attempting to establish that once and for all that Congress does have the sole power to declare war. The War Powers Act, I'm not going to say there's no debate about the War Powers Act. We include that in our filing, and the gentleman who has written extensively about it is aware of the defects of the War Powers Act. We're trying to get some clarification from a court on that. But I will say, if we are able to get standing on this, if the court will go beyond what the Supreme Court did in 1999 and saying that, this is just a political question and dismissing it and saying Congress ultimately has the power of the purse, if we get beyond that and go to the real deep meaning of Article 1, Section 8, we may see a whole new day here where no executive will in the future be able to go and declare war without checking with Congress. The founders were very clear about not wanting the power of war to be put in the hands of an executive. solely. And so they balanced it by making sure that Article 1, Section 8 defined that as Congress has this power. Now, one more thing. The gentleman said it's not a war. Now, I ask you, if another country sent 2,000 planes over our missions, over the United States, and some of those missions drop bombs on us, would that be an act of war against the United States? Because that's exactly what we've done in Libya.
Robert Turner.
Well, you're missing a number of things. First, the Founding Fathers understood the concept of force short of war. When Thomas Jefferson was president, at his first cabinet meeting on March 15th, 1801, he and his cabinet members decided to send 2/3 of the American Navy halfway around the known world to the Mediterranean, with instructions that if upon arrival they found the Barbary powers had declared war on the United States, they were to so disperse the force under their command to sink, burn, and destroy their ships wherever they found them. The fleet sailed on June 1st. On December 8th, Jefferson finally reported it to Congress. No one in Congress complained the president had acted improperly. Remember, you keep saying this is a NATO operation. This is an operation under Chapter 7 of the UN Security Council. When the Senate passed or consented to the ratification of the UN Charter in 1945, their unanimous report said the use of American forces to carry out a Chapter 7 decision of the Security Council would not be an act of war, but an act for preserving the peace, and therefore would not affect the exclusive power of Congress to declare war. When the UN Participation Act was before the Senate in December of 1945, Senator Burton Wheeler of Montana introduced an amendment that provided that the president could not send U.S. military forces to carry out a Chapter 7 decision of the Security Council without first getting the approval of Congress by joint resolution in the specific case where the Security Council wanted to act. That was defeated by more than a 7-to-1 majority, getting fewer than 10 votes, and leaders of both parties said this violates the obligation we have made under the UN Charter to assist in the keeping of peace. And remember, you talk about the president's duty to see the laws faithfully executed. In Article 6 of the Constitution, the Supremacy Clause says this Constitution, laws made pursuant to the Constitution and treaties made under the authority of the United States shall be the supreme law of the land. The president has a power and a duty to carry out the international obligations of the United States under treaty. So this is not a new issue. Neither Vietnam nor Korea were presidential wars. We can talk about that if you would like. In Korea, Truman repeatedly asked to go to a joint session of Congress and actually had the State Department draft what today we would call an authorization to use military force. And members of Congress, he personally consulted repeatedly. Members of Congress said, stay away from Congress. You've got the power to do this under the Constitution and the Charter. In Vietnam, Congress passed a statute, an AUMF, by a 99.6% margin, authorizing the president to use force. During that debate, Senate Foreign Relations Committee Chairman J. William Fulbright was asked, are we giving the president authority that could lead into war? He said, that is the way I would interpret it. So, it is a myth. It was a popular myth that gave Congress cover when the people turned against the war to suggest that Congress was not a full partner in getting us into Vietnam.
And it's interesting that we have a Reagan attorney who is defending President Obama right now, and we have Dennis Kucinich, one of the most progressive members of Congress, who is suing the President of the United States.